Welcome to my channel. Today I'm going to talk to you about what precedent is. I'm here in central London. Behind me I have the Supreme Court of the United Kingdom, and over here the Houses of Parliament. So let's go take a closer look. So many of you, when you think of the English legal system, will think of the common law. What is the common law? Well, it's law which is developed right here in the courts through precedent. And what is precedent? Well, precedent is a rule which is made by a judgment by a court, and that rule must be followed by other courts which are lower down the hierarchy, and sometimes those precedents even bind the court which makes them. Now, it's a common mistake to think that the common law is not written down, because it is. Precedents are contained, and the court judgments which make those precedents, which set those precedents, are recorded in the law reports. And these are cited as authority in litigation when cases come up and go to court. Precedent is incredibly important for the common law because it ensures consistency. If judges didn't have to follow precedent in cases which had similar facts, then of course we would not know what the law was, and it would be very inconsistent and unclear. And what is precedent? Well, in a court decision, in a judgment, we normally find several things. First of all, the judge will state the facts of the case. Then we will find the applicable law, which is relevant to the case. And then there will be the judicial reasoning. The judge will talk about how he reached his decision. And this reasoning is known as the ratio decidendi. Nice Latin word there, which means the reasoning for the decision. This part is the precedent. This part is the thing which needs to be followed, and it's the thing which sets the rule. The other things which the judge says are known as obiter dictum. This means all of the other stuff. And whilst it doesn't set a precedent, it's what's known as persuasive precedent. It may be used to argue that the courts should make a particular decision in another case. Of course, the courts don't always have to follow precedent. There are some ways for them to avoid it. The first option is to distinguish the case, and this is where the case before the courts is sufficiently different from the case which set the precedent. The facts are different, and therefore different law should apply. This is known as distinguishing. The second option is overruling, and this happens where a higher court, in a different case to the one where the precedent was set, changes the decision of the lower court, the precedent which was set by the lower court. This is known as overruling. And finally, we have what is known as reversing a decision, which is where a higher court in the same case changes the decision of the lower court. That's known as reversing a decision. There are some other ways, but these are the most common. And it's safe to say that as much as possible, courts try to follow precedent because they recognise the, first of all, supremacy of Parliament, that Parliament is the supreme legislator in the UK and the most important body that makes law. And secondly, they recognise the importance of consistency in the law. Of course, if you've got any questions or comments, if you're watching this on YouTube, you can just comment below. I'd love to hear from you. So thanks for listening and see you next time.